Hi, this is Jim Cunningham. How do trusts work? We're going to get in depth. We're going to take a deep dive. Enjoy. So, how do trusts work? Big question, big common question. How do they work? Who are the players? Well, you can think of a trust as a bucket, right? And this bucket has a handle, and the trustee is holding on to the handle. And you put stuff in the bucket. You put your house, your stocks, your bonds, your mutual funds. Other things stay out of the trust. These are typically going to be your IRAs, 401ks, annuities, life insurance. That ownership typically stays out of your living trust for a lot of reasons that we get into in our other videos on our YouTube page. And this will be posted on YouTube. But if you are watching this on YouTube, we have a whole page or whole YouTube site that is dedicated to all things estate planning. And one of the things we do cover in depth are IRAs and 401ks and annuities. All trusts have three things. Every single valid trust has a trustee, again, the person holding onto the handle, the person in charge, the human being with a heartbeat doing stuff, okay? A beneficiary, and this is typically a person, could be a charitable institution, but typically a person who gets the economic benefit of whatever this trust is holding. Now, if it's your living trust, it's you for your lifetime. And then when you stop living, right, when your heartbeat stops, somebody else becomes the trustee, and somebody else becomes then the beneficiary who has the economic rights, right, to the things that are in this trust. And a corpus, you have to have stuff in a trust, otherwise it's not a trust. And again, trusts take care of your assets while you're living. The idea is that they avoid probate, and this is it's a common thing that people want to avoid, and we'll get into that in a little bit more detail, why it's a really good idea. They take care of your assets while you're living, they avoid probate, and they avoid a conservatorship if you become incapacitated. So if your heart is still beating, but your mind is gone, you can't do stuff, right? You can't pay the bills, you can't buy and sell property. You just can't. Someone else steps in and does that. And again, that's part of this trust administration process. There are mechanisms to protect your financial legacy. So when you do leave this earth and you leave your stuff behind, and newsflash, that is what happens. You can't take it with you. I think we kind of all know that. But the idea is whatever material legacy you're leaving behind, you ask yourself, do you want to protect that from divorce, taxes, and lawsuits of the people who are inheriting from you? And there are some methods that you can use to protect that. Most living trusts start out as revocable trusts, meaning you can change them, but they do become irrevocable typically when a person dies. Not always, but if there's like a married couple and one passes away, sometimes that trust stays revocable. But on a very high level, when you pass away, your living trust does become irrevocable, and a revocable trust can be amended or changed during the lifetime of the person who holds that power. So, how many kinds of trusts are there? Well, how many kinds of ice cream are there, right? 31. There's probably more, but there's a list of different types of trusts. So when we talk about a living trust, we're just talking about one kind of trust. And there are some other trusts that we handle a lot that kind of lawyers who are doing estate planning frequently handle. The living trust, an irrevocable trust is another one, a life insurance trust, an IRA beneficiary designation trust. We call that the IRA inheritance trust or the IRA legacy trust. That is a wrapper, that's a protector if you have significant IRA assets, that protects those assets for your loved ones after you're gone, and that is funded, or those assets go in there after you're gone. Certainly a special needs trust if you have a loved one with special needs. And then there's a variety of other type of trusts. And for those of you who have invested in certain businesses, the qualified subchapter S trust is another real powerful tool, especially for Californians and other residents of states where there is a state income tax. So why do people use trusts? Why isn't a will just good enough? Why do they do this? Well, people use trusts because they tend to be the most efficient vehicle for estate planning, for tax planning, and for asset protection. Now, when I'm talking about asset protection, the context I'm talking about here specifically is an inheritance or a legacy you leave somebody else. So there are many types of trusts out there, but fundamentally, estate planning is to give the person who's doing estate planning, and if that's you and you're watching this video, it gives you peace of mind. And really, that's why people do planning. Now, This is a simplified, believe it or not, this is a simplified living trust for a married couple. So we have Hal and Wanda Lopez. And what they've done is they've created the Hal and Wanda Lopez Trust dated February 2nd, 2013, which they have done a restatement on. So meaning they set up their trust in 2013, but there have been a lot of changes in the law. So maybe they come in 2023 and we do what's called a restatement of trust. What is a restatement? We throw out all the terms and we replace those terms with all new terms. And the idea here is that as Hal passes away and then as Wanda passes away, there is stuff that needs to be done. And this is what I'm talking about when I say human beings with heartbeats need to do stuff. There are things that have to be done. Do you need a lawyer for this? I'm going to say yes, because I'm a lawyer, right? Do you always need a lawyer for this? I can certainly think of an exceptional circumstance where you wouldn't, but you should always check with a lawyer. And the reason why, and you can certainly check with our firm, Cunningham Legal, because it's about half of what we do on a given day is help people through this process. But the most important part of this is you don't know what you don't know. And you may be leaving a lot of money on the table. You may be overpaying on your taxes. You may be missing out on a lot of opportunity by just checking in with the lawyer. Now, sometimes these are very small engagements and sometimes they're much larger. It just kind of depends. It's a little bit like how long is a piece of string. One thing I do want to highlight, with your living trust holds your real estate, your stocks, your bonds, your mutual funds. And as I mentioned, it does not hold your IRAs, 401ks, annuities, or life insurance. That is typically covered by your durable power of attorney. So there's a living trust and a durable power of attorney. Those are typically done when people do estate planning. I know we're talking about how do trusts work, but it's very important to understand that that durable power of attorney is very important, because if a person is incapacitated, right, if they can't do for themselves, like their heart is beating, but their mind is gone, you would use a power of attorney to deal with the IRAs, the 401ks, the life insurance. However, once the person who signs the power of attorney, which is called the principal, not the principal of the grade school, right, but principal of, the person who signs the power of attorney, once that person dies, that power of attorney dies with him or her. So it's very important to understand, and we'll cover a little bit later how we treat different IRAs and life insurance differently. Roles of people named in the trust. Who does stuff and who doesn't do stuff? Great question. There are some people who are along for the ride, and there are other people who are doing all the rowing. The trustee is rowing as the laboring oar. The trustee is doing all the stuff. The beneficiary is sitting back and waiting for their check. So remember, every trust has a beneficiary. There's different kinds of personality types. There are different kinds of people out there. And remember, many people are married or they have a life partner. And so there's somebody talking in their ear like, oh, you're not getting enough. Well, you should do this. Or, your brother was always the favorite and that's not right. And, you really need to stick it to him and you really need to question everything and you really need to look over his shoulder. And if this is sounding familiar to you, number one, you might want to think twice about being trustee, right? But secondly, there's a lot of stuff you have to do. And we're going to talk about that. And if this is you, you really need to pay attention to this because this is really high value content for you. Well, which is best, being a trustee or a beneficiary? I'd say being a beneficiary is probably better than being a trustee because a beneficiary does nothing and gets everything, right? A trustee does a lot of work. Sure, they might get paid for what they do, but they don't get anything out of the deal. Now, sure, a trustee can be a beneficiary. So in that sense, they're getting something, but really the trusteeship, being a trustee can frankly be a thankless job. And I would say the people who do it, try to do it on their own, it's the most thankless job they might ever have. That is why I would really encourage you, if you're watching this, check in with the lawyer. A lot of times the lawyer has a very small involvement, and many times the lawyer has a tremendous, huge involvement. There's always value there. So it's something to understand about lawyers and legal fees. A lawyer should not charge a fee unless you're getting greater value than the fee that is charged, right? So a lot of this is peace of mind. A lot of this, there's a lot of stuff trustees have to do. And as we'll see, you're not quite sure what it is that you're supposed to do as trustee, because there really is typically no master plan that includes all of the things you need to do unless you go with the lawyer, right? But trustees have to do a bunch of stuff. Beneficiaries don't. Remember, trustees cannot be jerks. And if you're a trustee and you say, I really don't like that beneficiary, I'm going to be a jerk to that person, you might want to think twice about that. Certainly talk to a lawyer about that, right? But beneficiaries can be jerks. They can be rude. They can be demeaning. They can, be excessively demanding. And there's really not a whole lot a trustee can do, quite frankly. All right. Now, if you're one of those beneficiaries, I'm not encouraging you to do this, but this is more if you're a trustee, just to understand that really being vindictive, you really can't do that as a trustee. And again, just because somebody files something in court does not mean that the person has challenged the trust. So this is very important. Many times a beneficiary, someone who's receiving something, is not happy with something, and they will file a court action. That is not necessarily going to be a contest where they lose their right to inherit. So what are the rules, right? When do they apply? Trustees, you need to understand, trustees have 100% personal liability for everything that goes wrong in a trust. And really, they don't benefit if it goes right, right? If you're a trustee and something goes wrong, you're 100% personally liable for that thing going wrong. And the rules of the trust are found in the trust, meaning if you're the trustee, you must follow the terms of the trust. You must also follow the statutes, and that's found, believe it or not, in something called the probate code. And in California, we have something called the California Probate Code. That California Probate Code has rules, has statutes that say, hey, if you're a trustee, these are all the things that you need to do. In addition to following the terms of the trust, you need to follow the statutes as they're written. And then we also have doctrine and case law that you have to follow. And you're not going to know that unless you talk to a lawyer. So you can see why it makes sense. You know, this really isn't a DIY. I would say it's not enough to look at the terms of the trust and say, look, I'm complying with the terms of the trust, and that should be good enough. Well, that's not always good enough, right? Because you can be doing other things that run against the laws that they're written, and we'll see what those are. Different rules apply at incapacity and death. So this is a kind of a nuance. And I think many lawyers don't frankly get this. But if you have an asset, if a person has an asset titled in their name and they have an asset in a living trust, and they might have a jointly held asset like a bank account with a child, or a payable on death or transfer on death asset, there is an order of liquidation, which accounts you draw down first. And if you draw down on the wrong account and you're the trustee, guess what? You're 100% personally liable. So very important, especially in incapacity, to pay attention to trust administration. I would say the rules are written by and for legal professions, not for normal people. Now, if you're not a lawyer, you're a normal person. If you're a lawyer, you're not a normal person. So these rules are written for people who aren't normal, which are lawyers, right? And who's going to interpret those rules? Other lawyers and judges. So you really do almost need an interpreter. And that's sometimes I feel like as a lawyer, I'm just kind of interpreting in many days, right? The rules are arcane, they're cryptic, and sometimes they are counterintuitive. This goes back to the First Crusades back in 1096. It's a long time ago, right? A real long time ago. So the whole concept of trust goes back to the Crusades. And I would recommend that you seek out competent, savvy counsel. This is absolutely not a do-it-yourself project. So what does a trustee need to do? So there are a lot of things that a trustee needs to do in addition to following what the terms of the trust say. A trustee must act in the best interests of the beneficiaries. They cannot use their position for personal gain. It's a little obvious, but it may not always be obvious, because you say, look, I'm following the terms of the trust and I'm going to sell this property to myself for under market value. Yeah, well, you're not dealing fairly with the trust and with the beneficiaries. You know, that even though that may be permitted, right, theoretically under the terms of the trust, that runs counter to case law and to statutes. The trustees have to file tax returns. It does not say in the trust that you have to file a tax return many times, but you do. A trustee has to make distributions to the beneficiaries according to the terms of the trust. And this is very important, in a timely manner. There's a weird rule in California that says if somebody is getting a dollar amount, let's say they're getting $10,000, and you do not make that distribution within a year, you have to pay them interest. The trust has to pay interest. And guess what? If you're the trustee, how are the other beneficiaries going to feel about you paying out of their share interest on maybe a distribution you should have made? Many times trustees are held personally liable for that. The trustee is responsible for managing the assets according to the terms laid out in the trust. What if the trust is not specific? Now, this is, you may get something, you may have a look at an 8 or 10 page trust and it's not specifically detailed to give the trustee guidance. What does a trustee do? Well, there's less certainty, right? And so this is why trusts are a little bit longer, is because there are a lot of situations that as lawyers, when we're trying to think, gee, when this person passes away, whenever it is, maybe 30 years from now, are we covering all the bases? What's the world going to be like in 30 years? So that's why these tend to be, in a well-written trust, they tend to be a bit longer. A trustee must keep accurate records of trust assets and transactions and make these available to the beneficiaries on request. So if you're a trustee and you say, look, I'm the trustee, I have full discretion, I don't have to share anything with my jerk brother, you actually do have to share information with your jerk brother, and he can take that information if he doesn't like it and turn around and file an action in court that very well may not be a challenge to the trust. Now, this is why you want to engage a lawyer to pay attention to this and kind of guide you. Something else I do want to say, if you're a trustee and if you're a trustee and you're seeking advice and using trust funds, if you ever stop being trustee, that file goes to the next trustee. And if the next trustee is your jerk brother, you might want to think about hiring your own lawyer with your own funds to advise you about trust matters. Now, you're going to have to pay that out of pocket, but that is one way to preserve the privilege. So a bit of a hack there, but something to be mindful of. And a trustee must provide beneficiaries with regular accountings of trust assets and transactions. What is an accounting? An accounting it's like a bank statement. We started with this much money, this much came in, that much went out, this is what's left, signed under penalty of perjury. That's essentially an accounting. I'm making this is like the 30,000 foot view on that. Sometimes these run many, many pages, but you get the idea. So what's a sequence of events? This is when someone passes away. So what should you do? What should you do first? What's going on here? Well, typically people need to locate the operative legal documents. So this would be the living will, or the living trust, the will, the powers of attorney for property management, and advanced healthcare directive, which is the healthcare power of attorney. You want the power of attorney for property management because you want to know, hey, if somebody's in there and they're running around using this durable power of attorney, you need to let them know that the person's passed away. Now, typically they're going to know, but they have to be notified. And if they're not notified, then their power kind of lingers a little bit. So it's a good idea to reach out to that person if it's not you. An advanced healthcare directive also can dispose of a person's remains. I would also recommend that if you're the trustee, look at the provisions of the will and the living trust. I mean, yes, it's written in legalese, but it is written in English, and that's something you certainly can go over with a lawyer. But I would just preliminarily look at it to make sure it is what, if it says a living trust, this is a living trust, right? You want to make sure, because sometimes documents get jumbled. Also, obtaining certified copies of death. And I would say get at least 6. That's kind of a baseline minimum. It's kind of a pain in the neck to get them later on. They are a little bit more expensive if you get them through a funeral home, but it's important to get these. And then I would say you really do early on want to seek out a savvy lawyer. Cunningham Legal here, one of our lawyers can certainly help you, even for the simplest of estates. Now, and I'll tell you why, is because sometimes things look simple and they're not. And I would say that many times the size of an estate is inversely proportional to its complexity, meaning the smaller the estate, many times there are more complex legal issues. Then you inventory the assets, everything that's in the trust bucket. And this is really important. You do, if you're trustee, you need to pay attention to things that pass outside of the trust, because both those assets are typically included in a person's estate when they pass away and subject to death taxes. So life insurance, the death proceeds on life insurance, subject to death tax. All that IRA money you have, or 401k money, subject to death tax, even though in many instances, all of that money in an IRA is going to later be taxable as income. So you do get taxed twice, right? Without representation, because now you passed away, right? This is your estate we're talking about. You do get taxed twice. And so those can be what we would call toxic assets to a certain extent. So really if you have a larger IRA, pay attention to that during your lifetime in order to mitigate the taxes. And that's something we can certainly help people with. And again, IRAs, 401ks, and annuities, you have to pay attention to those. Those go all on the death tax return. So if the value of an estate is of a certain size, you must file a death tax return, or a Form 709, which is the federal estate tax return. If you're a resident of another state and pass away other than California, or have property in another state, sometimes you have to file a state death tax return. So this is something that you really do need to work with your A team, as it were. And we do discuss that in other webinars. So this is your CPA, attorney, financial advisor, the 3 of them working together on a kind of a 3-legged stool. We value the assets as of the date of death. And that's important even if you lose a spouse. And you say, look, all I have is a house, and I've got, bank accounts, and I've got this Apple stock. You still should have an appraisal on your house because in many instances, that house gets a new cost basis, which means the surviving spouse can sell property and avoid a significant amount of capital gains tax. So very important to have properties valued. And then you distribute the assets. And, I would say that some things that are kind of missed sometimes is keeping a reserve or a refunding agreement. So it's very important to understand, once you're a trustee and you distribute those assets, you have no legal basis to recall those assets to pay debts that may pop up unless the beneficiary has agreed to refund money back to the trust to pay those debts if they do pop up. Trustees, again, are 100% liable for everything they do and everything they don't do. If a stock goes down in value, the trustee is personally liable. Now, we went through kind of a hellacious market in 2022. A lot of people's portfolios were down. It was the worst year for a 60-40 stock portfolio, worse than 1929, worst ever, 2022. Hopefully 2023 will be better. But a trustee is personally liable for those losses unless you have an investment policy statement or investment policy memorandum. This can shield the trustee from personal liability. So this is a thing that, when stocks are going up and we talk to clients about that, they go, I don't know, I don't know if I want to spend the legal fees that, by the way, are paid by the trust. I don't know if I want to spend that money to do an investment policy statement, but the people who did, and when the market went down and when the jerk brother calls and says, hey, I want you to dip into your own pockets to give me back the money I lost because you were trustee when the market went down, those people are very happy that they have this as a defense. So very important to think about if you're a trustee and you have assets that, that can go down in value. So lots of duties in the California Probate Code. Again, you have to administer the trust according to law. You have to use that trust solely for the benefit of beneficiaries. You can't be giving the property to other people. You have to deal impartially, even if it's your jerk brother. You have to deal impartially with your jerk brother. You can't play favorites. You can't use the property for your own benefit. And one big one is asking for a waiver before a distribution. Now, sometimes it is common for lawyers to say, look, if you sign this waiver of accounting, I will then make a distribution to you. That's not enforceable. It's nice to do that, maybe not. But if you're a lawyer watching this or you're a trustee, asking for a waiver to do something that a trustee has to do just isn't enforceable. Now, there are other mechanisms to shield the trustee and maybe other trusts or other estates from liability, but just understand that asking beneficiaries to sign a waiver as a precondition to a distribution, I don't think is enforceable. You have to preserve trust property, obviously, and maintain property. You've interest-bearing accounts, those sort of thing. You just can't let property, you can't let this 4-unit apartment building stay vacant for 4 years as a trustee. You've got to make that property productive. You have a duty to keep trust property separate from other property. So you just can't, if you're a trustee, you say, well, I'm going to close out mom's accounts and put all that money into my personal account and then write checks. It's a really bad idea. Okay. You have a duty to designate property as property of the trust. So maybe if you have some personal items or some collectibles, you would want to identify with a list or some other type of indication that those are properties of the trust. A real clear example is if you're a trustee and there's a piece of real estate, your name goes on there as trustee of that property, not individually. So it would be Jim Cunningham, trustee of the Smith Trust, not Jim Cunningham, an individual, right? So it's very important to have those designations on there. You have to enforce trust claims to property. So if the trust is entitled to payment, and here's where this gets a little sticky, what if mom lends money to your jerk brother? And there's a note. You have a duty to enforce that note. That's probably going to tick your brother off. So that, believe it or not, that happens more than you might think. You have to take steps to defend actions against the trust, and a duty not to delegate to other people to perform trust duties. So you can't just be a trustee in name only. We call that a TNO, a trustee in name only, and you just give all the other responsibilities to your personal assistant or something like that. That's just not going to work. You've got to do it if you're the trustee. So what not to do? People, if there is one thing not to do when it comes to a trust in a trust administration, do not go to the ATM and withdraw cash. That is probably the single biggest mistake, most common mistake out there. If you are going to withdraw cash, if you have no other option, talk to your lawyer, document it. It is such a red flag with judges, such a red flag with lawyers. Immediately, we think you're just using that, pizza and beer money, right? You're just pulling money out and going to have a good time. Really a bad idea. Things not to do: do not fail to maintain, conserve, and protect trust assets. Change the locks on the door, get insurance on the property. And that's a tough one for an unoccupied structure, is it's many times you have a hard time getting a policy like a homeowner's policy if it's not occupied. Do not borrow, invest trust assets for your own benefit. There's a criminal term for that. It is called embezzlement. People do serve time in prison for that. So do not do that. Do not pay yourself excessive trustee fees. How do you know what an excessive trustee fee is? It depends. Talk to a lawyer, figure it out. This is where you need some professional counseling. And failing to invest trust assets prudently, don't invest them in a balloon party for your friends. It's a bad idea. Not making distributions when required by the trust. My jerk brother is getting $100,000. I'm going to wait 5 years to give it to him. Yeah, not really a good idea, right? You need to follow the terms of the trust. And failing to render accountings to the beneficiaries. And I will tell you, many times beneficiaries reach out to us and they're very frustrated because they say, look, mom died 10 years ago. My brother's still living in the house and he hasn't talked to me for 8 years. That is a complete breach of trust. Okay. I mean, if that trust says distribute everything equally to the 2 kids, that's a real problem for the trustee. He's using that for his own benefit. He's not communicating with the beneficiaries. He's failing to make distributions. So that's a very common situation. Many times when that trustee goes out and hires a lawyer, that is sometimes the most needle moving thing that a person can do, because the lawyer will tell the brother who's in the house for 10 years, like, you can't do this, right? You either need to, you got to distribute the property, sell it, pay rent, cut a deal, work it out, but you can't just do nothing, right? And I would say I would chalk that up into failure to account. And then incurring penalties on tax returns. This is kind of a big one. And, a lot of people miss this, especially for California. Remember, the federal system is an annual system. California is a quarterly system. If you have more than $1 million in income in a given quarter, which you can do if you screw up the distribution of an IRA and leave it to your living trust and don't kind of have some type of emergency remedial action, that can be deemed a full distribution in that one quarter. And also not listening to your lawyer. This presumes you get a lawyer. And when people don't listen to legal advice, I will tell you as a practitioner, as a lawyer, it's very frustrating, because a lot of this is what we call black letter law, meaning there's no gray in here. You have to do A, B, and C. And when the client says, I don't want to do A, it's very frustrating for the lawyer. So just listen to your lawyer, please. Just make it easy on the legal profession. It's hard enough. Record keeping and accounting. Trustees must account to the beneficiaries. Again, if you would withdraw cash, where's that money going, right? That's a really bad idea. And again, an accounting is like a big bank statement. Money comes in. This is the deposits, the payments, and then we have what's left over at the bottom, and all those numbers add up. And if they don't add up, a trustee can be held 100% personally liable. We see it as lawyers. We see it quite often. This is not an infrequent thing where trustees end up holding the bag. Again, an interest-bearing account, a separate checkbook register is often helpful, like a separate account, like in the name of the trust. You have to get an employer identification number, which is a 9-digit. It's kind of like a social security number with 2 digits and a dash and 7 other digits. That you have to get that when someone dies. You really shouldn't be using, well, actually you shouldn't be using the decedent's social security number. It's a kind of a bad idea. And balance your checking account monthly. It's a good idea. And maintain careful records of all transactions. Dividend reinvestment on mutual funds will drive your CPA and your lawyer bananas. So that's something I would look at. If someone is dividend reinvesting on mutual funds, that is probably the single most complicated thing to account for. And you may just want to stop the dividend reinvestment at that point. Why do people stop serving as trustee? What's going on? Well, there are 4 main reasons. Resignation, so where they say, I don't want to do it anymore. When you resign, you typically have to render an accounting. You are removed. Now, you can be removed by a court. You can be removed by somebody called a trust protector. And we cover trust protector in other videos on our YouTube page. Incapacity, that's where mentally you become incapacitated. It's very common for people when they have their own living trust to become incapacitated. And at that point, somebody else steps in as trustee. Certainly death. And each method, again, triggers a slightly different consequence. If you're incapacitated or you pass away, there still may be a duty to account. And it's the person who is helping you out. If you're incapacitated, it might be your conservator. And if you passed away, it would be your executor. Those are the people who end up having to do an accounting if an accounting is required. And if a person is a trustee and not the sole beneficiary, there is this duty to account when you stop being trustee. So who pays for that's a different question. These are really complicated, thorny questions. Even if a trustee dies, again, the executor or trustee has to do the accounting.